The parties are yet to enter evidence and the matter has been wrongly listed in the hearing column, Lordship. And affidavits are also not yet filed.
14.
Yes, Lordship.
I'm for the special counsels.
So what do you want?
Lordship, the matter may be listed for order because the parties has not yet entered appearance.
Oh, not yet.
It has been wrongly listed.
On the last occasion, it was referred for mediation.
No, it was not referred for mediation.
But since the party has not yet appeared, it's still premature.
Oh, okay.
Yes, Lordship. And Lordship, one more thing, Lordship.
On preamble, on the I learned Mr. Bidep, learned counsel for the petitioner, has submitted that this matter has been wrongly listed in the hearing column, when actually some of the respondents are yet to appear in this matter and pleadings are not yet completed. Accordingly, as prayed for, this is matter after 2 weeks in the order column.
Please, Your Lordship, this item number 13, Your Lordship. I just received the paper book today only. So if this matter may be listed after 2 weeks, the counsel is a legal aid counsel.
Have you?
I could not inform because I have not met. I have not seen him today.
Premier by mistake. This is matter after 2 weeks.
Hello, Brechal.
If it may please your lordship, item number 11, we are ready for the hearing, but the respondent adjourned. The matter may be taken up after a week's time for hearing.
2 weeks, 11 for premier by parties.
My Lord, may I make a request in this matter?
Which matter?
Item 11.
You are appearing for?
I'm appearing for the appellant.
You are not appearing for appellant?
He is the conducting counsel. I am assisting him.
Okay, but your colleague has already made his submission.
Yes, I just have a small request. If Monday or Friday can be avoided.
That will be March.
Okay.
12th maybe, 2 weeks would be.
Not on. This is single bench matter. We'll have it on 12th then.
Most obliged, my lord.
As agreed to by the parties, this is matter on 12th.
Highly request.
Lord, item number 7. I'm appearing for respondent number 3 to 5.
Yes.
If this matter can be listed after 3 weeks, my lord, we are trying to figure out some way out if possible.
Okay. It will be better.
Yes.
Whether this matter has not been referred for mediation.
It has not been. It has not been.
My lord.
Anyway, whatever the case may be,
Yes.
even if it is not so, if the parties are willing to try and sort out the matter,
It can be in fact referred.
try. Yes, Mr. Kera, you are there in this case.
My lord, I am there with Mr. Paul Sincon for the same respondents. My lord, both
You are for whom?
We will be appearing for 3 to 5.
3 to 5, my lord.
Okay, you are for respondent.
Yes.
My lord, we are trying to make the headway because.
So we'll,
My lord, I would request at least, my lord, 6 weeks be granted. The reason is there are board exams going on now.
Should
And
we?
my lord, we are trying to find some.
No, Mr. Kera, that's okay. But should we refer this matter for mediation, or should the parties on their own try to negotiate?
My lord, it may be referred to mediation once so that the deadlock is broken at some stage once we appear together for mediation.
Your Lordship will seek instruction first, Your Lordship. About the
There
mediation.
is no harm if it goes before the mediation.
The thing is that we are now endeavoring that some logical conclusion is arrived at, we are able to reach somewhere, my lord. Because in this fight, my lord, we'll have to
We have
remember
completed
that
arguments already, Your Lordship.
the future of children is at stake.
Where is your senior?
He's on next, Your Lordship.
We'll take up the matter later.
My lord.
You inform us, yeah?
Yes, Your Lordship.
Or you try to contact the petitioner. If they are willing for mediation, we'll
Yes.
refer the matter from mediation. Okay. Pass over.
Your Lordship, I beg to mention item number 9. I appear for respondent number 3. Your Lordship, if this matter can taken up after 2 weeks. Your Lordship, this conducting counsel is not keeping well.
One week.
2 weeks, Your Lordship.
No objection, Your Lordship.
Yes, letter counsel appearing for respondent number 9 has sought for accommodation on the ground that the conducting counsel is not keeping well. Accordingly, as prayed for, this is matter after 2 weeks.
On supplementary list, item number 1.
morning, Your Lordship.
Yes.
5 minutes.
See, Mr. Yadav,
Yes, Lordship.
what you have to show to this court is whether the grounds of arrest was intimated to you, whether you are aware of such grounds of arrest, because if not, then
Then a case.
there may be relief given to you.
True.
But if those grounds of arrest has been intimated to you, you are made to understand what are the charges against you, or the allegation against you. I think you don't have a case, because the only ground here made in this petition is that the grounds of arrest has not been made known to you,
Mandate was not fulfilled.
which is mandatory, whatever the case may be. So, how are the grounds of arrest to be
Communicated.
conveyed? In what form, in what manner? As Mr. Shulai has pointed out the other day,
True.
it has to be in the format of the arrest memo. In the arrest memo, there would be some, portion or indication where the grounds of arrest is made known to you. We just have to see and check from the records. If it's there, it's there. If not, then. I think the other day, Mr. Shulai, you have pointed out.
Lordship.
You have pointed out that
Darshan.
where's the-
Lordship,
Conduct
kindly
of
have
Memo of
page.
arrest?
Kindly first have page 38, Your Lordship. Lordship, that is the intimation of the ground of arrest, and Lordship kindly turn to page 39. Lordship will kindly find the signature of the accused.
The LTI.
LTI, Your Lordship, the thumb impression, Your Lordship. That is the thumb impression, Your Lordship, at page 39. Then, Lordship, kindly turn to page 42. That is the order dated 17/9/25, Your Lordship, passed by the learned Chief Judicial Magistrate. If Lordship kindly have a second paragraph from the bottom.
Yes.
Lordship, kindly see, on being asked, the accused submitted that he knows why he has been arrested. So he's aware, Your Lordship. He is aware. He's aware why he has been arrested He's aware, Your Lordship. And also he was afforded, Your Lordship, the legal representation, Your Lordship. If Lordship kindly see that second paragraph, seen and finished the forwarding report so and so submitted by the IO, praying to remand the accused to the judicial custody for 14 days on the ground mentioned therein. IO is present and pray that the accused may be sent to judicial custody so as to enable him to conduct a proper investigation without the accused tampering with evidence. Learned ALADC Miss so and so has no objection to the same. So it appears from the order of the learned Chief Judicial Magistrate, Your Lordship, on the first day of production of the accused, he has been afforded the legal representation, Your Lordship.
Yes, Mr.
Lordship, if Lordship I refer to that judgment again, that 25 SCC online 1702, Your Lordship, at paragraph 20.1.1.1, Your Lordship.
Oh, that one, yeah.
Lordship, the copy I have given on that day, Your Lordship. Can you have paragraph 20.1.1, Your Lordship? This is exactly the case here, Your Lordship. May I read it, Your Lordship? The learned counsel for the respondent accused contended that the arrest was illegal as the ground of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section 50 CRPC, now Section 47 of the BNSS. This submission, however, is devoid of merit. Article, next, Your Lordship, Article 22(1) of the Constitution mandates that no person who is arrested shall be detained in custody without being informed as soon as may be of the ground of such arrest, nor shall he be denied the right to consult and to defend by a legal practitioner of his choice. Similarly, section so and so require that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other ground for such arrest. The constitutional and statutory framework thus mandates that the arrested person must be informed of the ground of arrest, but neither provision prescribe a specific form or insists upon written communication in every case. Judicial precedent have clarified that the substantial compliance with this requirement is sufficient unless demonstrable prejudice is shown. In Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest ground in substance. Then Lordship kindly see 21.5. While Section 50 CRPC is mandatory, the consistent judicial approach has been to adopt a prejudice-oriented test when examining alleged procedural lapses. The mere absence of written ground does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of the fair opportunity to defend. Then point 1.6, Your Lordship, the High Court, however, relied heavily on the alleged procedural lapse as determinative factor while overlooking the gravity of the offence under Section 302. Here, the case of 302, Your Lordship, while in the present case, Your Lordship, it relates to the seizure, Your Lordship, under the NDPS, Your Lordship. It was seized from his possession, Your Lordship, because he was traveling in an MTC bus, Your Lordship. He was caught by the police. Everything was recovered from his possession, Your Lordship. That is what the FIR, Your Lordship. Then, Lordship, kindly see 21.7, Your Lordship. In the present case, the arrest memos and remand record clearly reflect that the respondent were aware of the reason for the arrest. That is exactly the case here, Your Lordship, in the present case. They were legally represented from the outset and applied for bail, but bail is not being filed, Your Lordship. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapse. In the absence of demonstrable prejudice such as irregularity is at best a curable defect and cannot by itself warrant release on bail. Then, Lordship, kindly see, if I take Your Lordship to Lordship, yes. Lordship, I'll continue reading, Your Lordship. As reiterated above, the High Court treated it as a determining factor while overlooking the gravity of the charge under Section 302 IPC and the assistance of prima facie case. It relies on Pankaj Bansal and Prabhi Purkehasta heavily relied by the accused, Your Lordship, in the present case is misplaced, as those decisions turn on materially different facts and statutory context. The approach adopted here is in consonance with the central principle that procedural lapse in furnishing ground of arrest absent of prejudice do not ipso facto render custody illegal, entitle the accused to bail, Your Lordship. Lordship, even Lordship, the decision rendered by the Honorable Apex Court, Your Lordship, in Mihir Rajesh Shah, State of Maharashtra, also it said, Lordship, the right of the accused to be informed of the ground of arrest. That much only, Your Lordship. So this, Your Lordship, this judgment which I have relied, Your Lordship, will fit in this present case, Your Lordship. No prejudice has been shown, Your Lordship. The ground of arrest has been communicated to him, Your Lordship. He signed by a thumb impression, Your Lordship. He was afforded the legal representation, Your Lordship, on the first day of production before the court by the learned Chief Judicial Magistrate, Your Lordship. Everything is. So my humble and respectful submission, Your Lordship, considering the fact that it is a seizure of a intermediate quantity of the drugs, Your Lordship, along with those tablets, Your Lordship, considering the fact, Your Lordship, that this will have a huge impact on the youths of the state, Your Lordship. It's coming to the state, Your Lordship. My humble and respectful submission, Your Lordship, no leniency should be shown to the accused person. That is my humble and respectful submission. Apply, Your Lordship.
Lordship, of course. Sir has relied on darshan, but that is one amongst many which contemplates as to how grounds of arrest are to be furnished. He also spoke about Mehir. Mehir actually says it must be done in writing again. I'll get to that. If I may just put it across your honourable self in a chronological manner, it would be better. So it all started with Pankaj Bansal, which was passed in 2023. Thereafter came Prabir Purkasta's judgment, which I'm heavily relying upon, as Sir said. I'll take you to para 13 of my petition, Lordship, where I've quoted the relevant paragraph.
Yes.
Para 13. So Your Honour asked me as to how these are to be communicated, the grounds of arrest. First, we must understand as to what grounds of arrest are, for which we must read paragraph 48 of Prabir Purkasta's judgment, which is quoted in this said paragraph, if I may be allowed to read it out. So I'll just start from the concerned para, 48, it's within quotes. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason for arrest and grounds for arrest. The reason for arrest, as indicated in the arrest memo, are purely formal parameters, which to prevent the accused from committing any further offence, for proper investigation of the offence, to prevent the accused person from causing the evidence to disappear or tampering with such evidence in any manner, to prevent the accused from making inducement, threat or promise to make any person acquainted with the facts of the case so as to dissuade him from disclosing such facts, etc. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the accused person all basic facts on which he was being arrested so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, grounds of arrest would invariably be personal to the accused and cannot be equated with the reason of arrest, which are general in nature. Lordship will stop here. What we come to understand from this is the grounds of arrest are factual in nature. It must communicate to the accused person the facts which necessitated the arrest of the accused person. And I took your honourable attention to the intimation of grounds of arrest, which is at page 38. 38. So as relied to it, I had actually relied on it the same also. I claim with clean hands and took the honourable court's attention to every paper. Now 38. If you see 38, it's basically a pre-type format wherein only one column has been ticked, which signifies or which says you are suspected of being involved in a cognizable offence punishable with imprisonment for a term that may be less than 7 years or which may extend to 7 years with or without fine. Only that column has been ticked. And my contention is this, Your Lordship, that at the best, even if we do assume for the sake of argument that this document was indeed given to the accused, then too at the best, it is only intimating the accused of the nature of the offence. Grounds of arrest are facts which lead to the arrest of the accused person, which must necessarily be communicated to the accused. At the best, what this conveys is the nature of the offence. That is it. In terms of paragraph 48, this is not the ground of arrest. Now, Lordship, as to how it is to be conveyed is another question, of course, which is answered in paragraph 19 of Prabir Purkasta's judgment, which I have quoted in para 14 of the petition.
Yes. Yes.
Para 14 of the petition, Lordship.
Please.
Yeah. Your Honour, I've highlighted para 19, if I may be allowed to read it.
Please.
Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of UAP or for that matter any other offence has a fundamental and a statutory right to be informed about the grounds of arrest in writing, and a copy of such grounds of arrest have to be furnished to the accused as a matter of course and without exception at the earliest. We'll stop here again, Your Lordship. What do we come to understand? It must be done in writing. That was the mandate which was given in Prabir Purkasta's case. And when you give it in writing, you must factualize it. You must tell him as to what led to his arrest. Now, let us also remind ourselves that we are dealing with a matter which is of a chance recovery. There must be strict compliance. There must be more strict compliance because it's very easy for the police to allege that he was found in possession of contraband. It's a case of chance recovery. So he must be informed in writing about the factual aspects. Now that was not done. I've already taken to the intimation. Lordship, I must also assert that there is no evidence on record which suggests that this intimation which we just read, page 38, was handed to the accused. Of course, it bears the signature of the accused person. But I also dispute that this document was given to the accused person. It must be done in writing. Why? Because the remand order, which is at page 41. 42, Your Lordship.
Yes.
Okay, the third last paragraph. On being asked, the accused submitted that he knows why he has been arrested. The accused submitted that his family members know about his arrest and will inquire from his family members whether they will be able to acquire the services of an advocate, etc. It ends there. It doesn't quote that the grounds of arrest or the intimation was given to the accused person as per the mandate of Prohibited Broadcaster's judgment again. It must be given to the accused. Now, there is no evidence. And the remand report as well, which is at page 27. Your Lordship. This is the first remand order. First remand report. 28. The last paragraph.
Yes.
In the course of preliminary investigation, the below noted accused person was brought and handed over at Latrambai Police Outpost, East Gentia Hills, on such and such date by SS so and so. The below noted accused person was informed of his grounds of arrest. So here, at the best, what this remand report says is that he was informed verbally, not in writing. There's no evidence on record which suggests that the grounds of arrest were given to the accused person in writing. And even if you assume that it was, all that it conveys to the accused person is the nature of the offence and not the facts which led to his arrest. So we rest here. I am saying that, okay, he's entitled to bail because of non-compliance of the mandate in Prohibited Broadcaster's judgment. Now, sir brought a judgment which is State of Karnataka versus Darshan, where a basic separate view was given by the Honorable Apex Court. It said it need not be done in writing. But Your Lordship, I do realize and I do apologize, on the date when we were having this hearing for the first time, I had relied on a judgment titled Ahmed Mansoor and others. It must be there. That day, Your Honor cautioned me that live law journals shouldn't be supplied, so I supplied a fresh one. Ahmed Mansoor versus the state represented by Assistant Commissioner.
Have you supplied?
I did yesterday. I supplied a fresh copy of the judgment. Ahmed Mansoor and others versus the state. Yeah, that one.
It's not here.
I did. I'm certain I did. Ahmed Mansoor, yes. I've highlighted certain paragraphs, Lordship, which are basically quotations of Prabir Pukasta and Pankaj Bansal. But this judgment also dealt with the judgment relied upon by Sir. I'll take you to first, second, third last para. The citation is on top as well, Your Lordship. This
Yes.
citation is on top. I'll take you to the third last paragraph of this judgment. Third last paragraph.
Page?
The third last para, I suppose, is at page 7, Your Lordship.
Para?
Third last paragraph of the judgment. Absolute third last paragraph. So it would be page 7, Your Lordship. Page 7.
Yes.
Sorry, it will be page 6. Page 6, Your Lordship. Page 6, the last paragraph. In State of Karnataka versus Darshan. Starts from there. I've highlighted the relevant portion. In State of Karnataka versus Darshan. May I?
Just a moment.
May I?
Just a moment.
Oh, sorry.
Yes, please.
So, So the judgment relied upon by Sir, which says that grounds of arrest need not be informed in writing, etc., came out on the 14th of August 2025. This judgment, which is before your good self now, Your Lordship, Your Honourable Self, Ahmed Mansoor, was passed on the 14th of October 2025, after the passing of the judgment relied upon by Sir. In this paragraph, if we start reading, Your Lordship, it quotes and it delves into this particular judgment also, and it says, in state of Karnataka versus Darshan, etc., the facts governing are quite different. It was a case dealing with the cancellation of bail, where the charge sheet had been filed and the grounds of detention were served immediately. So the contention was that of the state that the grounds of arrest were served. Now in this case, I'm contending that the grounds of arrest were never served to me. There's no evidence, neither does the remand report, neither does the remand order speak about the furnishing of the grounds of arrest to me. And even if they were, all that it conveys is the nature of the offence. Let us continue, Your Lordship. Reading. So the facts are different, because it was dealing with cancellation of bail where the charge sheet had been filed and the grounds of detention were served immediately. This court has in fact given its approval to the decision in Vihan Kumar versus State of Haryana and another. Similarly, in Kasir Reddy, Upendra Reddy versus State of Andhra Pradesh, this court was pleased to hold in para 27 that the object underlying the provision that the grounds of arrest should be communicated has been explained by this court in Vihan Kumar versus State of Haryana. Therefore, the law laid down in Vihan Kumar versus State of Haryana has been approved and reiterated in the aforesaid decision. Lordship, what was held in Vihan Kumar? If I may just take your honour's attention to the paragraph before that, the one which we just read. There's another paragraph which reads Learned Senior Counsel.
Yes.
Before that, there's another paragraph which I've highlighted, Your Honour.
Yes.
So this is the supplementing judgment in Vihan Kumar's, where the Honourable Court in Vihan Kumar only had said, hence the requirement of communicating grounds of arrest in writing is not only to the arrested person but also to the friends, relatives, or such other persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22 of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. So even in Vihan Kumar, it was said that it must be done in writing. I'll take you to the last paragraph again, Your Lordship, of this judgment, Mansoor's judgment, last paragraph. In such view of the matter, we are inclined to hold that the present appeal deserves to succeed only on the ground that the mandate of furnishing the grounds of arrest at the time of securing the appellants has not been complied with. Therefore, we are not inclined to go into the merits of the case. So only on this accord, and after discussing the judgment relied upon, Sir, the benefit of release was still given to the accused person. I'll rest it here, Lordship. And of course, there's one more thing I must counter, and this is just to clear all ambiguities, if they may so exist. Now, Sir is relying on a judgment which was authored by 2 judges. I am relying on a judgment, Prabir Purkaista, Your Lordship, which was authored again by 2 judges. Now, in this scenario, what is to be done? Which is to be considered? That was also answered to in a judgment of the Guwahati High Court, where it requotes a judgment of the Apex Court in paragraph 16. And that judgment is titled, Your Lordship, Surat Jamal versus State of Assam. I've already supplied a copy. I'll just take a moment. Surat Jamal versus State of Assam. I'll take you to paragraph 16, Lordship, which is at page number 8.
Yes, sir.
Para 16 of this judgment. I've highlighted. Para 16. Are we there?
Yes.
Are we there? I'll read. This case, this Guwahati High Court judgment also confined itself to communication of grounds of arrest, etc. But this is a relevant paragraph which I must quote. Para 16, I'll start reading. Further, it is a settled proposition of law that the high courts or the subordinate courts should decide the matter on the basis of law as it stands, and unless specifically directed by the Honorable Supreme Court to await an outcome of a reference or review petition as the case may be. In that context, also a decision of the Honorable Supreme Court can be relied on, which was reported in 2023 SSC Online SC 114 Union Territory of Ladakh versus Jammu of Kashmir versus Jammu and Kashmir, wherein in para 35 of the judgment it has been held. We are seeing before us judgments and orders by high courts not deciding cases on the ground that the leading judgment of this court on the subject is either referred to a larger bench or a review petition relating to the same is pending. We have also come across examples of high courts refusing deference to judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the proposition of law we make it absolutely clear that the High Courts will proceed to decide matter on the basis of the law as it stands. It is not open. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not open to a High Court to refuse to follow a judgment by stating that it has been doubted by a later coordinate bench. In any case, when faced with conflicting judgments by benches of equal strength of this court, it is the earlier one which is to be followed by the High Courts, as held by a 5-judge bench in National Insurance Company Limited versus Pranesh Sethi. I'll stop here, Your Lordship. So it clarifies, in such a scenario where there are two conflicting judgments of the same bench, which one is to be followed, the earlier one is to be followed. Now, in this case, Prabir Purkasta was passed on the 15th of May 2024. The one relied upon by Sir was passed August 2025. So in this scheme also, Prabir Purkasta is to be followed. It will come into play, Your Lordship. I'm just covering any ambiguity if it may so exist.
That is, you see, provided there are conflicting views.
Conflicting. What he provided was conflicting, but the judgment, Mansoor also covers this judgment relied upon, sir. And anyway, I had to bring this up. And finally, Your Lordship, sir also had spoken about Mihir's judgment. Now, actually, Mihir's judgment, it was retreated. The same position was retreated again. This was passed, and this was authored by our Honorable Chief Justice as well of India. And he reiterates here that it must be done in writing. I'll take you to the last paragraph of Mihir's judgment, Your Lordship, which is at page 48, paragraph 56, Mihir Rajesh Shah.
What is the citation?
2025 INSC 1288.
Lordship will have SCC 2026 1 SCC page 500, Your Lordship.
I have supplied though. I can supply another one. I have.
I have the 2026.
2026, Your Lordship, 1 SCC 500, Your Lordship. Then what my friend has referred is, that is paragraph 56, Your Lordship.
Paragraph 56.
56, Your Lordship.
No, it's numbering in conclusion. Anyway, Lordship, yes. I will refer to the judgment which I had placed.
What does it say? Just read.
Mihir Shah in paragraph 56, which is the concluding paragraph.
Yes,
I hope Your Lordship is possessed with the copy I had given.
Yes, I will refer to this. I have the.
Anyway, I'll just give a copy.
2026. Fine. Just read out.
But the paragraphs may be renumbered.
Just read out.
Right. So it's the concluding portion of Mihir's judgment.
Yes.
And it says in paragraph 56.
Yes.
This is as per downloaded from the Supreme Court's website. In conclusion, it is held that the constitutional mandate of informing the arrestee of arrest is mandatory in all offences under all statutes, including offences under IPC.
SCC, Your Lordship, that is para 66, Your Lordship.
66, yes.
66, Your Lordship.
I'll continue.
Yes.
Next, the ground of arrest must be communicated in writing to the arrestee in the language she understands. I'll just stop there. It reiterates that it must be done in writing. I don't think I need to go any further.
These are principles which have been reiterated.
So this judgment also is covered, the one which is relied upon by senators. That is all, Your Lordship. Just one more aspect, Your Lordship. Of course, charge sheet has been filed and it's just a case of intermediate quantity. On those accords also, leniency may be given. That is.
What is the stage of the case?
CC.
CC. Oh,
Consideration of charge.
May I reply, Your Lordship? Lordship, kindly have again page 42. Second paragraph from the bottom, Your Lordship.
Just a moment.
42.
Page
42, Your Lordship, of the application. That is second paragraph from the bottom, Your Lordship. Again, Lordship, kindly see in the extract of the case diary. Lordship is with me.
Yes.
The memorandum of arrest of the accused, the intimation of ground of arrest, Your Lordship. It is there, Your Lordship. And
yes.
And even if Lordship kindly turn back to page 39 of the application. Oh, I'm sorry, Your Lordship. 28. No? Page 28, Your Lordship. And then Lordship kindly have page 29. Lordship kindly have two enclosures. Kindly have Lordship kindly have serial 7.
Oh.
Intimation of ground of arrest. It is there, Your Lordship.
Page 28.
Page 29, Your Lordship. That is the forwarding report by the investigating officer, Your Lordship. It starts from page 28, Your Lordship, and it ends at page 29. Lordship kindly see the enclosures. Lordship kindly have number 7.
Yes.
Lordship. Lordship, I also have an alternative submission, Your Lordship.
Yes.
Lordship, considering the fact, Your Lordship, that this is a seizure of heroin, Your Lordship, and other tablets, Your Lordship, this will certainly have a serious impact on the society, Your Lordship. My humble and respectful submission, Lordship, if Lordship inclines to hold that there is non-compliance of furnishing the ground of arrest, then Lordship will kindly grant that liberty to the state, Your Lordship, to take recourse to law, Your Lordship, as per the judgment rendered in Ahmed Mansour, Your Lordship. If Lordship kindly have a page 7 of that judgment, that Mansour judgment, Your Lordship.
The one I'm relying on.
Mansour, the one which has been relied by my friend, Your Lordship.
It says the recourse may be taken if misuses liberty of that nature.
It doesn't say. Lordship kindly have a page 7. Lordship, I'll read somewhere in the middle. Therefore, Lordship has got it.
Yes.
Therefore, we are not inclined to go into the merit of the case. However, while setting aside the order passed by the High Court and consequently setting aside the order of arrest and remand, we would only say that liberty is granted to the respondent to take recourse to law to arrest if a case is made out. Lordship kindly, if Lordship holds that there is no substantial compliance in furnishing the ground of arrest, Lordship kindly grant us that liberty, Your Lordship.
I've highlighted that portion as well.
Highly obliged, Your Lordship.
What the parties?
Lordship.
Passes orders.
Highly obliged, Your Lordship.
Good day, Lord.
Daily list item number 1.
May it please Your Lordship. Lordship, service has been reflected upon respondent number 1 and 2.
Your Lordship, I am interpreting on respondent number 2.
You are paying for respondent 2?
Yes, Your Lordship.
Your Lordship, respondent number 1 are yet to appear. Respondent number 1 are yet to appear in this matter, Your Lordship.
Service is completed on
Respondent number 1 and 2 both completed, Your Lordship.
and 3?
3 is already expired, since expired.
Have you made any amendment?
It's been struck off, Your Lordship, as per your order dated 27/1/26.
Struck off. That was the order dated?
27/1/26.
So you issue fresh notice on respondent 1. Eh?
Oh, yeah, that's right.
Heard, Mr. Letter Counsel. for the applicant. Who has submitted that the notice issued upon the respondent number 1 has been affected, and affidavit of service has also been filed for this court. Mr. Learned Counsel has entered appearance on behalf of respondent number 2. Thanks. Since the respondent number 1, in spite of receipt of service, has not entered appearance till date, therefore the applicant is directed to take fresh steps for issuance of notice upon the said respondent, indicating that this application will be heard on the next date. Even in the absence of such respondent, if it chooses to remain absent from these proceedings. As prayed for, this is matter 2 weeks.
Your Lordship, I pray let the matter come after 3 weeks, Your Lordship, as of now, because I have not received copies of the application.
I'll serve him today. I'll serve during the course of the day.
Let it come after 3 weeks, Your Lordship.
Applicant to enclose copy of this order along with the said notice issued upon the respondent number 1. As prayed for, this is matter 3 weeks.
All right.
Item number 2.
This matter has been
My
heard
lord, it was heard, my lord.
substantially.
Yes, my lord.
What
The
is
issue is like, my lord, we have to satisfy your lordship placing some judgments regarding the power of deputy commissioner, my lord.
Please, the facts. We've heard. Just those things. No, and and that one judgment that the court wanted, no? What you showed me last time.
yes?
Lordships, insofar as the facts are concerned, my lords, I've heard us at length. Two aspects, my lords, I had to place before my lords. First was the, my lords, the Assam Land and Revenue Regulation. My lord, what I suggest, my lord, if my lord allows, let us give our written synopsis of submissions. We may exchange and thereafter we start our hearing, my lord. My lords, I've already heard this matter insofar as my lord is already aware of the facts, my lord. Now we can exchange our.
They will file their written argument.
We'll file, my lords, because I have concluded. I'll just point out.
Yes.
My lords,
According to us also,
a query had fallen from this honorable court, my lords, regarding any prior instance of this.
Yes.
We found one judgment, my lords. This is 19.
More particularly on the jurisdiction of the
Deputy Commissioner's power.
This is the one. Well, it's 1965, SCC Online, Guwahati, page 28. Relevant paragraph. Para 9, if my lords can have a look.
Para 9.
Balance. Well, as I'll read from para 7 onwards, it will make it clear. Reliance is placed by the Council for the State on Rule 26 of the Settlement Rules under the Assam Land and Revenue Regulation. Rule 26 reads as follows. Subject to the general control of the state government, the Commissioner shall have the power to confirm on settlements or also cancel any settlement made in contravention of these rules. The footnote attached to this rules reads, the power conferred on the Commissioner under Settlement Rules 26 is neither appealable nor revisional and is not affected by the Commissioner's Power Distribution Act. If a settlement is obviously in order or obviously contravenes the rules, there is no objection on these lines. The Commissioner's powers remain as in Settlement Rule 26. But if there is an issue raised on either account, the case becomes one in appeal under so-and-so of the Assam Land and so-and-so. The plain reading of Rule 26 makes it clear that the power exercised by the governor is neither an appellate nor a revisional power. It is only an administrative power, and further that it only gives him jurisdiction to confirm or cancel settlements and not to cancel a periodic patta issued in pursuance of an order of settlement. Once the patta has been issued, it can be cancelled for violation of the terms embodied in the patta. In the present case, there is no violation of the terms of the patta. It is also clear that the footnote of the jurisdiction of Commissioner is only in cases where there has been an obvious contravention of the rules. If there is no dispute with regard to the violation or otherwise of these rules, Rule 26 does not authorize the Commissioner to cancel the patta in his administrative capacity. The reason behind this footnote is obvious. As an order of the capacity, the reason behind this as an order of the settlement officer is appealable under so-and-so to the Commissioner. If there is any controversy as to whether the settlement was proper or not, such a controversy can only be decided by the Commissioner sitting in as a court of appeal. If and when any appeal is filed against the order of settlement or refusal to settle and not under Rule 26 of the settlement rules. If the Commissioner can in his discretion in every case settle and cancel settlement in exercise of his powers under Rule 26, then the provision of appeal will become nugatory. It cannot be said that in the present case there was any obvious contravention of the rules. The order of the Commissioner thus in the present case was without jurisdiction, and Article 14 of the Limitation Act will not apply to the present case. So this is with regard to the power of the Commissioner under Rule 26. Malads, one more decision is there. This is 1950 Malads, SSC
No,
online.
the action taken in the impugn order is under the Assam Land and Revenue Regulation.
Revenue Regulation Settlement Rules, Malads. The law, as I understand, Malads, is that once a settlement is made, that settlement is made. And Malads, the second authority which I'm placing is again on this issue. That's once it's made, Malads, it can only be cancelled by the regular courts, Malads. Insofar as Malads, Commissioner's power is concerned, it is only if there is contravention of the rules, then you can refer to Rule 26. This issue settles. If my lords have the second decision, my lords, this is 1950 SSC online, Guwahati, page 28. Extra copy for the state. You've not made copies. How can you? I'll just give you a copy. Well, this is here, it is para 6.
Yes.
It may be true, as the learned DC appears to think, that the amicable partition will influence the revenue authorities in granting two separate periodic pattas to the appellant and the respondent respectively, may have been brought about by mechanisms of SK. They may or may not have been fraud. Assuming there was fraud, nonetheless, the revenue authorities under the regulation have no power to cancel the periodic patta. They must refer the party aggrieved by the alleged fraud to the civil court for settlement of the respective rights of the parties. Even, my lords, if there is a case of fraud, then also, my lords, that power has to be exercised only by a civil court. It is only the civil court which can then, my lords, declare that yes, there has been a fraud or otherwise, and my lords, the power to cancel the patta would then vest with the civil court. There is a series of decisions of the Honorable Supreme Court on this regard, my lords, insofar as Rajinder Singh, this is 2008 9 SSC, my lords, page 368. Copy for the court.
What is this citation?
Well, this is 2008 9 SSC, page 368. Relevant paragraph will be, my lords, paragraphs 17 to 20. Your lordships will find it at page 371. He given the list of books. My lords have it. Para 17, my lords, at 371. Last paragraph down below.
Yes.
It is well settled that revenue records confer no title on the party. It has been recently held by the Supreme Court in Suraj Bhan that such entries are relevant only for fiscal purposes, and substantive rights of title and ownership of contesting claimants can be decided only by a competent civil court in appropriate proceedings. It is clear from the record that the so-and-so, my lords, this would not be relevant. I think the relevant paragraph will be only para 17, 18 and 19 are with the facts of this case. Para 20, my lords, may kindly have a look. We therefore dispose of this appeal by granting liberty to the parties to take appropriate proceedings in a competent civil court by making it clear that the observations made in the course of revenue authorities, also by the High Court, will not come in the way of the parties in a suit as and when proceedings have been initiated for the purpose of determination of substantive right of ownership. So either way, my lords, if there is a claim against me, insofar as the ownership of the property is concerned, that would have to be agitated by the concerned claimant before a competent civil court. It is only that court, my lords, will then have the power to then declare either fraud or anything else, my lords, would have to be declared by a competent civil court. Admittedly, my lords, in this case, there is no proceedings before a civil court. Well, it's one more, I'll just place, this is 2003 2 SCC, page 464, Civil Court's Jurisdiction on Annulment of Patta.
2004?
Well, this is 2003 2 SCC, page 464. This is Mahili Bajranji. Extra copy. The relevant paragraph is paragraph 6. Well, it's paragraph 6. If it starts from page 469.
Yes.
If my lords kindly turn the page and come to page 470.
Yes.
Well, it's pin set C. If my lords kindly have a look. Such entries.
C.
Yes, my lords. Such entries.
Yes.
Such entries made in land records, even as per the code, shall be presumed to be correct only until contrary is proved. Section 111 of the code provides that the civil court shall have jurisdiction to decide any dispute to which the state government is a party or not, relating to any right which is recorded in the record of rights. Consequently, it could not legitimately be claimed that the tehsildars or authorities exercising powers of mutation, original, appellate, or revisional, have accorded the status of civil courts or courts of exclusive jurisdiction, and for that matter to use such orders as a basis or source for ascertaining a claim of res judicata before a competent civil court in a subsequent suit involving adjudication of title of the immovable property. The mutation proceedings before revenue authorities are not judicial proceedings in any court of law and does not decide questions of right. Questions of title to immovable property is a tried proposition and principles laid down in Thakur so-and-so versus so-and-so. In essence, well, and there's a series of other judgments, but essentially laid down the same principle. Which one is it? Janamara. Paragraph? It's not here. Janamara? I've not seen that. Janamara? You have copies? Well, it's one more decision. This emanates from Shillong itself. This is 2009 5 GLR, page 768. Copies for the state. The relevant paragraph is paragraph 11 at page 772.
Para 11.
My lords, para 11, pin set H. My lords, if my lords kindly have a look.
Yes.
This court is in full agreement with the views expressed by the Honorable Chief Justice of the then Assam High Court that patta cannot be cancelled as there is no provision for cancellation of patta in the Assam Land and Revenue Regulation 1886, which is applicable within the state of Meghalaya, including GHDC. However, a patta can be annulled subject to non-payment of land revenue. Periodic patta means a patta for a particular period, and if the patta holder has paid the revenue, then he is entitled to get the title over the land mentioned in the patta as per law. So, my lords, this read in conjunction with the other judgments, my lords, that I have placed before my lords. For cancellation of patta, my lords, once it has been issued, once an order of settlement is issued and on the basis of that a patta is issued, if there is any grievance of any party, my lords, you have to go before a competent civil court. You place the rule 36 and the Meghalaya interpretation of statutes. That's required. Show me. But if I may draw your lordship's attention to, because here the entire proceedings are under Rule 26 of the settlement rules. If my lords kindly have a look at Rule 26, my lords, the Assam Land and Revenue Regulation. These are settlement rules. My lords, kindly have a look at Rule 26 of the settlement rules, my lords. Yes,
Page?
Well, if you are referring to the same book, it would be page 244. May I assist, my lords, because these rules are very confusing. There are 3 sets of rules, my lords. I'll just assist, my lords. Till then, my lords can refer to this book. Stick out the settlement rules. Please take out the settlement rules. The court's copy is here, Malit. Lordships can refer to that. Court's copy is here, Malit.
Same.
Same. The page is different. Rule 26, if I am just read, Malit.
Yes.
Confirmation and cancellation of settlements subject to the general control of the state government. The commissioner shall have the power to confirm all settlements and also to cancel any settlement made in contravention of these rules. So the expression he used here is Millet's commissioner.
Commissioner.
Millet's under the Meghalaya interpretation of General Clauses Act, Millet's. Should have opened the relevant page. Please open the relevant page and give it to the court. Page 5. Copy for the state. Well, that's so many days you still not prepared with it. Well, it's if my lords kindly have the first page, I'll just place the rules. Well, this is the Meghalaya interpretation of General Clauses Act 1972.
Then
Section 3 deals with definitions, Millets.
Section 3.
Millets. And 315 deals with commissioner.
Yes. Are there any distinct powers between commissioner and deputy commissioner?
Yes, Millets. That's why I am pointing this out. Commissioner is Millets, and 15 your lordship will see. Commissioner means the chief officer in charge of the revenue administration of a division. Deputy commissioner is Millets one step below the commissioner. There's one commissioner Millets for the entire division, that would be the state. Deputy commissioner is Millets, there may be various deputy commissioners from the various districts. So he would be the district head, but commissioner Millets would be of the entire state, that entire division. That is why Millets there's a specific definition of commissioner.
Yes. What is the definition for deputy commissioner?
Deputy commissioner, Millets, is not defined in this. I think it will be defined in the...
It's there in 20.
Of the?
20.
Rule 20.
Yes. In the General Clause Act.
20 is daughter commissioner.
Deputy commissioner.
Is it
Daughter commissioner?
No,
it should be deputy commissioner. Millets. There's a typographical error.
Deputy commissioner?
It is deputy commissioner. My friend has the book. Well, this is the official publication.
Any corrigendum made?
I don't think so, Millets. My friend has the Millets, the book. It says deputy commissioner. Here it says deputy commissioner.
Act 1972.
This you got it from where? This is on the Meghalaya government's official website. This is General Clauses Act. You will not get it here.
Definition 320, my lord.
320. No, here it is come as daughter commissioner.
Daughter commissioner.
You have not given the book for Meghalaya. It's there, no, in the list of books. Show me the list of books.
My lord, only in 15, administration of a division, and in 20 it talks about
District.
Administration of a district, my lord. Division meaning thereby the state, and district for one particular district, deputy commissioner.
Deputy commissioner means the chief officer in charge of the general administration of a district. And Millet's commissioner is in respect of the entire division.
That is understood.
Millets. So this power under Rule 26, Millets, is vested with the commissioner, not with the deputy commissioner in the first place. And otherwise also, Millets, I have pointed out under Rule 26, the power of the commissioner is also restricted. So in cases of any kind of Millets cancellation or otherwise, it has to go before a civil court, because that only the civil court has that power. You will prepare a short note, Millets, and just place it.
Yes.
Thereafter, I'll give my reply, my lord. Because according to me, my lord, the deputy commissioner's order does not suffer from any infirmity, my lord, because he has rather.
You have not.
No, my lord.
If my learned friend begins ballots, I can then give my
No, let my friend give me so that it will be easy for me to reply accordingly, my lord. Is the petitioner, let him give slight advantage to me to prepare.
You suggest a date, short date.
10 days time.
What 10 days?
We'll take, well, if it's 10 days, we'll again forget what has been argued, and we've taken too long in this matter. So, today is Thursday. By Monday, Malaj, we'll file our written notes of argument.
We'll have it on Tuesday, the 3rd.
Third. I'll file the written notes of argument by Monday.
Thereafter, my lord, I'll take only 10 days time.
Or thereafter 10 days.
Or Mr. K. Paul, counsel for the petitioner,
Kindly give all the judgments.
who has concluded his argument and has submitted that he may be allowed to file his written argument.
I'll do so.
Mr. S. Sanguta Leonard,
GA.
additional senior GA,
Yes, my lord.
has submitted that he may be allowed to reply on the next date.
Yes, my lord.
Accordingly, as prayed for, as agreed to by the parties, this is matter for further hearings on 3rd.
Highly obliged, my lord.
Item number 5.
Can you see me if you know? Yes.
What's it like? Time also, if you start, it's long. We may not be able to complete.
In fact, this matter, my lord, at the motion stage was heard for interim, and the interim order is very detailed order, my lord. And interim order covers all the aspects, my lord. If that is made absolute, I think.
That I'll make my submission. If my friends start, I'll counter that, your lordship. That is only a prima facie finding by this.
Usually, interim orders are in that nature only. It would not be. That is why he has.
Was relying on that.
It is a fit case to just to make that order absolute, my lord.
Judgment, your lordship, because in that, your lordship, that power has been given. If the state can raise that issue again, your lordship.
You can always agitate anything.
Lordship, yes.
You start.
My lord, government is raising 10 objections, my lord, in their affidavit. I'll just point out to their affidavit, my lord.
Go to the facts of the case first.
List of facts was. No, if it isn't.
The rest of the impute order. What page? My lord, this is a writ petition filed by Jaintial District Council, my lord. And we have come against page 65, annexure 5, my lord.
Oh. Not by a private party?
No, my lord. This is by, I'm appearing on behalf of District Council, my lord.
Any private respondent here?
No, my lord. We have come against the action of the state government, my lord. The state is trying to close down the check gate set up by District Council, my lord. And their contention is the District Council has no power to set up the check gates, my lord. So that is precisely the issue, my lord.
If I'm not mistaken, was it in this case?
My lord.
You said there's a similar case being.
But that has been disposed of.
That has been disposed. Your lordship was that is from East Castle, lordship. Lordship in that.
By a coordinate bench or a division bench?
My lordship is allowed the petition, my lord.
By this bench only, your lordship.
State filed an appeal, my lord, and your lordship's order has been upheld by the division bench, my lord.
No,
With
that is in a different context, your lordship. That is with regard to the collection of customary toll by the traditional chief. So it will have no bearing or no relevance with the present case, your lordship.
Because it struck me since I recall parties making reference
That
to
is that is completely on a different issue, your lordship.
Yes.
But this is the collection of toll by the district council or the national highway, your lordship. Whether that is permissible, your lordship.
Okay.
You can have on some other day, your lordship. Can you have this matter on some other day? Will we'll have on some other day.
When?
Lordship, after 2 days. Lordship, can you have on 17 March, your lordship? 17 March.
On pre-made by the parties, this matter.
17 March, your
On
lordship.
17 March.
Lordship. Apply, your lordship.
Item number 6.
Already filed a written submission.
Your Lordship, I'm praying for 1 week's time to file on behalf of the state.
Matter has been heard.
Your Lordship.
May I please, Your Lordship? Your Lordship, I have filed our written argument in respondent 5 and 6 on MIDC. Today we have filed, Your Lordship.
Your Lordship, I've just received this copy from the from respondents number 5 and 6. Your Lordship, I'm praying for 1 week's time and we'll file ours also on behalf of the state, Your Lordship.
You have a separate stand in this matter.
Your Lordship, here our contention is that they are not employees of the state, Your Lordship. That is our contention. And the scheme that was granted to them, Your Lordship, that the Golden Handshake scheme, Your Lordship, was a one-time scheme, Your Lordship, on compassionate grounds. That is our main
That scheme was
contention.
affected through the state government or through the MIDC?
Through the state government, Your Lordship.
Through the
As a
state-
one-time measure only, Your Lordship, on compassionate ground. That is our contention, Your Lordship.
Okay. Mr. Counsel, for the respondent 5 and 6, I submitted that the written argument on behalf of such respondent has been filed today. Next, Mr. Narad G, appearing for the state respondent, has sought for some time to file the written argument. Accordingly, as prayed for, this is matter up to 1 week. 1 week?
1 week, Your Lordship. Obliged, Your Lordship.
Item number 7.
My lord.
Yes, miss. Any instruction?
Your Lordship, it's not suitable for mediation, Your Lordship. Matters has already been heard and issues have already been settled.
My lord, let this matter come up after my lord 4 weeks, because there are some exams are going on, my lord, board exams. So that will be over by April. By the month of April, my lord, second week of April.
How will that affect the
My
case?
lord, after all, it is regarding the school, my lord, and if suppose the school has to implement 7 CPC, my lord, I'm afraid, my lord, the school has to close down. We do not want any difficulty as on today, my lord. So let the exam be over. We'll see thereafter, my lord. We'll go for hearing.
Mr. N. Learned Counsel for the respondent.
3 to 5.
3 to 5. Managing committee. Big managing committee.
My lord, I'm also there for 3 to 5, my lord.
Same.
If two counsel make same submission on behalf of one party,
Same, my lord. Same.
Would that be an advantage to your case?
No, my lord.
So, why is the necessity for you to appear?
He's a ex-student from the same school, man. He passed out from the same school.
That should not be the consideration. Kau hunu tu? Has sought for some time for this matter to be for continuation of hearing of this matter on the ground that the examination in the school is going on. Which, if any decision is made in the meantime, would affect the management of the school as a whole. Accordingly, as prayed for, on consideration of such submission, that is adjourned. This is after 4 weeks.
Item number 8.
In this case, my lord, we sought for an amendment. Lordship has allowed that amendment. We have filed the consolidated writ petition. Only thing I fear, my lord, only thing I have brought on record, my lord, subsequent approval of the appointment letter which was under challenge. Now, in the original writ petition, they have filed their affidavit, my lord. My humble submission, that should be sufficient, my lord. Matter should not be delayed further.
But, in fact, my lord, we are coming to that point only. We would require, my lord, filing an affidavit response to the main writ petition.
New facts are brought in, of course.
No, only thing, my lord, this matter is being substantially delayed, my lord. Even the amendment application was pending for almost a year. On one pretext and another. My lord, they ensure that they file it by next day, your lordship.
2 weeks time maybe given, lordship will.
They ensure they file it, my lord.
Mr. Assistant Learned Counsel for the petitioner has submitted that the amended petition has been filed.
I have already filed.
Next, Mr. Chanda, Learned Counsel for the respondent. You are for respondent?
4 to 8, lordship.
4 to 8.
1, 2, 3.
You also would like to file your?
They never filed in the order.
Because earlier occasion it was not the. It may be necessary.
Because lordship is the government's order. Government has given the.
Learned Counsel appearing for the respective respondents has sought for time to file the subsequent counter affidavit. Accordingly, as prayed for, this is matter to 2 weeks.
Item number 10.
This is a matter where, my lord, the petitioner is seeking for appointment in the sanction post, or rather approval in the sanction post, wherein she is already serving since 2010, lordship. Primarily on the ground that the land upon which the school was situated, or is situated today, was donated by her family member, lordship. And if I may take your lordships through the...
Mr. Dev, if I can recollect, lordship, I think this court has made a query on the earlier occasion as to whether you fall under, there is a certain scheme as far as land donation in lieu of
lordship is
employment.
Because this was under the SSA, Lordship. So per se, that scheme, which is between the government, where there has to be a registered deed by the headman or Nokma or individual landowners, that is perhaps not applicable here, Lordship. But in what I wish to submit is that was not done here.
No, but you have, you see, according to you, we have not gone through the details. According to you, your land was donated for construction of the school.
My family member's land.
Whatever.
Lordship, yes.
You see, and that is that land has been donated to the government.
To the school itself, to the SMC, under the SSA scheme.
Okay, school.
To the school managing committee, Lordship.
School managing committee.
What has essentially happened is, Lordship, in 2010, when this SSA scheme has come, before that, my lord, there was a proposal to upgrade the school, which was already existing, as a SSA school. In the month of January, Lordship, all the teachers who are serving in the school today were appointed, 6 in total. And I was, Lordship, the land wherein the school was supposed to be upgraded under the SSA scheme, that land belonged to my aunt. And that land, Lordship, there was an agreement between my aunt and my father that the land which was belonging to my aunt, wherein the school is situated, is to be substituted with the land of my father, where there is a homestead. So an exchange was made, Lordship. And at the end of the day, the land where the school is situated now was in the name of my father. My appointment was approved by the government, Lordship, on 2 or 3 occasions as being the assistant teacher, being the family member of the landowner. Inquiry was held, Lordship, wherein it was found that school managing committee has committed certain illegalities while appointing the other teachers, and my case ought to have been considered, being the family member of the landowner. But they have not done anything, Lordship, and they are putting other people, and I am not getting the sanctioned pay scale since having served from 2010, Lordship. So that is the brief of the.
Just enlighten this court.
Lordship.
If a teacher or anybody for that matter is to be posted, in a certain any school under the SSA scheme, the proposal should come from the managing committee, or it comes directly from the government?
From the managing committee. They pass a resolution ideally, along with all their
saying that this person is recommended to be appointed as a sanctioned post under the SSA.
Lordship, yes.
Was that done in your case?
It was done. Approval was also given. But there are conflicting approvals by the government. There are conflicting inquiry reports by the government. Their own record appears to be, Lordship.
So if, see, at the end of the day, the issue of the land being donated and you being put in as a teacher will not come in the picture.
Lordship. So if I may just take a Lordship to few pages of my writ petition, Lordship, just to show what has happened here. If Lordship may please come to page 28 of the petition.
Page
28, Lordship, Annexure 1.
Yes.
Lordship, this is an appointment order issued by the managing committee before the SSA sanction was made by the government on 4th January 2010.
Yes.
And it reads, Lordship, that you are hereby appointed as an assistant teacher in so and so upgraded UP school, Majipara, West Garhwal district, Meghalaya, with a scale of pay which will be sanctioned by the government of Meghalaya for the school, and you are directed to join your service within 7 days from the issuance of this letter. So at that point of time, on 4th January, Lordship, the school was yet to receive the sanction under the SSA from the government. But I was appointed on the assurance that I will be given the sanctioned pay scale. Now thereafter, Lordship, I have joined on 8th of January. In the next page, my joining report is there.
Yes.
Lordship, now from 8th January till date, I have been in service in the school without any break. That is not disputed.
Okay.
Now thereafter, my lord, if Lordship would see page 38, I'm sorry, page 32. 32 is the type copy.
Yes.
Lordships, I am reading resolution 1 at the bottom. This is a resolution of 28 July 2010 after the school has been upgraded.
Okay.
So resolution 1, my lord, if I may read. It is resolved that the managing committee of so-and-so school in the meeting discussed that there are 5 assistant teachers and 1 headmaster already appointed by the said school managing committee previously with 1 so-and-so, 2 so-and-so. My name is at number 5, Lordship, Sujeta Das. Now after getting the grant in aid, the managing committee of the school proposes to sanction and select 1 Nazrul Islam BA headmaster and 2 Shah Jamal Rehman Bepari as the 4th assistant teacher under the sanction. So my name was not forwarded at that point of time, Lordship.
Yes.
Now thereafter, my lord, this resolution was not approved by the government and another resolution came to be passed at page 38 after 6 years, Lordship. Page 38.
Yes.
This is an emergent meeting of the managing committee held on 14 July 2016. 6 years down the line, Lordship. Resolution number 1.
Yes.
It says, my lord, that it is resolved that the SMC is thoroughly discussed as regard the disbursement of salary of the teachers in the school. It is clear that as per the government norms, only 3 number of posts are approved and sanctioned in the school, whereas 6 number of teachers are appointed as follows. Now, my lord, what I am trying to point out in this resolution, if your lordship would see the original at page 36, it's not very legible, but it would be relevant in my humble submission, the handwritten copy at page 36.
Yes.
Lordship, admittedly, the government said that we cannot approve for more than 3 teachers under the scheme. Now, my lord, kindly see page 36.
Yes.
At the middle of the page, my lord, where the names of the teacher are mentioned. It's little faded. First is 1 Nazrul Islam headmaster.
Yes.
2 is, my lord, it's Shamin Ahmad, assistant teacher. Then there's a gap of 1 line. Number 3, Shintu Das, assistant teacher. And then the resolution reads, my lord, for necessary approval. Now what has happened here is that this name of number 4, Shah Jamal Rehman Bepari, 4th teacher assistant, has been entered subsequently, which is very apparent from this the handwriting and the spacing and everything, lordship. So if despite the government's direction that we cannot approve the 4th teacher, who is he's a physical education teacher, lordship, there is no sanction under the SSA for a PE teacher. Still in 2016, they say, lordship, in the first part of the resolution, they say that only 3 posts will be sanctioned, but still number 4 is added and his name is again forwarded for the 4th post. Lordship, I file a complaint and thereafter...
Your name did not figure here?
No, again it was dropped. Again it was dropped, lordship. And thereafter, my lord, if lordship may kindly see page 46.
Then in the type copy, how come your name appears?
No, it's not there, my lord, in the type
page
copy.
39?
Page?
Page 39?
No, that is the top, my lord. They are talking about 6 teachers in total. 6 teachers in total, out of which 3 were to be sanctioned, and they have again forwarded the name of 1, 2, 3, 4 below that, page 39. And kindly see the resolution, page 39, if lordships are referring. First paragraph from the top. So far as the 3 numbers, if lordships have it.
No, where is the corresponding original?
Lordship, yes, that is there, my lord, at page 35. 35, resolution 1. My name is 2 lines on the top. Number 5, my lord, Sujeta Das. Oh, in rather faded, but one is Nazrul, second is Shintu Das.
9, 10.
Page 35. No, that 9, 10, 11, 12 is the members who were present in the meeting, lordship.
Okay, or yours.
Resolution number 1.
Resolution number 1
says that there are 6 teachers, and the names lordship may find it below, starting from 1 Nazrul Islam, 2 Shintu Das.
Yours is 4.
Mine is number 5, lordship, Sujeta Das. The S and the U is. Okay. So this is the. And if I may refer you to the type copy again, lordship, page 39. What was resolved is that out of the 3 teachers, I mean, out of the 3 sanctioned teachers, since there are 6 teachers, the entire sanctioned salary is to be shared along with the chokidar. That itself could not be permissible, Lordship, at that point of time. And even over and above this, in my humble submission, this name of number 4 was added illegally. And my name again was dropped to be forwarded as an assistant teacher, Lordship. Lordship, I had filed a complaint verbally, and thereafter, my Lord, if Lordship would see page 46. Lordship, this is an order of 19 December 2016.
Yes.
Lordship, issued under the letterhead of the SSA by the Office of the Joint District Coordinator. As per the office-wide number so-and-so, dated 4th January 2010, which is my original appointment letter, Lordship.
Yes.
The appointment of Srimati Sujata Das, such and such, is hereby approved as an assistant teacher of so-and-so school. And the copy thereof has been given to all the Lordship right from the directorate level.
After 6 years.
After 6 years, approval has come. Now thereafter, Lordship, again there is a claim and a counterclaim, and there is an inquiry conducted. Kindly see the report, my Lord, at page 49. If I may read, my Lord.
Inquiry on?
Page 49.
What is the basis of the inquiry?
Lordship, there was a complaint.
By you?
No, the complaint was made by another teacher, one Mr. Jugal Das. If Lord, I'll just read this, Lordship. Sir, Madam, in pursuant to the letter number such and such, dated 31st March, I have conducted an inquiry on so-and-so 25th April. A general meeting was held to discuss the matter relating to the appointment of teachers as well as complaint lodged by Jugal Das along with villagers of Majipara. So there were certain issues, Lordship. A complaint inquiry was made. And the report is, kindly see point 1. As per resolution 1 of the emergent meeting of Majipara so-and-so school held on 28 July 2010 at about 10 am, Shri Jugal Das so-and-so and Srimati Sujata Das for HSLC and DLED pass were also appointed along with 4 other teachers by the secretary so-and-so without approval of the concerned authority. And thereafter point 2. In pursuance of the letter dated 4th January 2010, all the 6 teachers have joined the school on different dates. And
you reading?
Resolution page 50.2.
Okay. Yes.
Now, my Lord, they say, according to resolution 1 of another meeting held on 14 July 2016, the SMC has directed the secretary, who was found absent in the meeting, to forward the names of 3 teachers, omitting the name of Jugal Das and Sujata Das without mentioning the reason thereof. Thereafter, my Lord, point 4, donation of land for the school. In accordance with resolution 3 of the meeting dated such and such, one Sarat Das, a close relative of Jugal Das and father of Sujata Das, has donated the land for the school in written argument on non-judicial, should have been stamped, using give and take policy, thinking in return her relative will be given jobs for that time and in future too. And lastly, Lordship, with regard to the approve, after knowing the number of sanctioned posts, the SMC of the concerned school has finally selected 1 Nazrul so-and-so as headmaster, 2 so-and-so, 3 Shintu Das and 4 Sajamal Depari, 4th teacher, during the meeting held on 16 July 2016 without informing Jugal Das, who was the teacher's representative. And the selection of the teachers has been approved by the joint DMC on 21st December 2016 after about 5 years. Whereas, my Lord, I had just referred to page 46. My approval was approved on 19 December 2016. 3 days later, it appears, my Lord, that my name has again been omitted, and these selection 1, 2, 3, 4 have been approved by an order of 21st December 2016. That too when the teacher's representative was not in the meeting, Lordship. So therefore, Lordship, kindly see Madam, in view of the above mentioned practice, I have also come to know the facts that the appointment of all the 6 teachers by the secretary is very much illegal, as it was done without approval of the authority, and because of which Sri Jugal Das and Sujata Das are seeking the approval of the appointment. As close relatives of the landowner and bona fide residents of Majipara, the SMC of the school should have considered while selecting the teachers for final approval. And I would therefore request you to kindly take necessary action against the school managing committee for illegal appointment of teachers and for taking 2 different decisions and resolutions and approval without the knowledge and recommendation of the in charge BM block mission coordinator. Now this is done, my lord. Then I am asked to submit a report, which I have done so at page 52 with regard to the factual background of how this land came to be donated, and lordship may refer to the type copy at page 54. What has happened is, lordship, on 21st of April 2010,
yes,
my aunt Sodo Das has given the land to the school, and thereafter, my lord, subsequently an agreement has been drawn up between Sodo Das and my father Sarad Das on 14/12/2017.
Are those relevant? Relevant consideration?
Basically, what has happened is, originally it was my aunt's land, and they changed their names, and now it has become my father's land.
As far as the school is concerned, they have
I
nothing
don't
to
see any dispute with it. It's in the name of my father. Originally, it was in the name of my aunt. That's all, lordship. But inquiry report is very clear that it was given by my family member. Now, thereafter, my lord, again, pursuant to all of this, at page 58, the Joint Director, my lord, of SSA, on 26th October 2018, reiterates, lordship, that Srimati Sujata Das, assistant teacher of so-and-so, is hereby approved by the undersigned based on the approval of the SDSCO dated 19/12/2016 and UDs dated so-and-so, and being the candidate from the family of the landowner. And thereafter, lordship, I have repeatedly approached them to give me the sanctioned post, to forward my name so that I can get the salary under the sanctioned scale. It is not being done, lordship. And on the other side, what is happening is, certain teachers are there. Salary appears to have been shared amongst staff, teachers, non-teaching staff, which is, my lord,
your concern is only as for
my approval in the sanction
approval,
scale.
yes, approval of
Lordship, yes.
your appointment.
Lordship, yes. And I am getting the salary which is being shared from the sanction scale. So even
that you have not been any.
I am not on
any
that.
complaint
On that, yes. So, lordship, now in the this is my case, lordship, in brief. Now in the affidavit, my lord, they have.
We'll continue.
Very well, lordship. Today.
When?
They have some difficulty in the
Next week?
Next week. Maybe.
On Mr. SDF, Learned Counsel, the petitioner has commenced his argument, but has not concluded the same. Accordingly, for the hearing will continue on the next date fix. As prayed for, this is matter after 1 week.
Item number 12.
Please, Your Lordship. Your Lordship, I'm praying for some accommodation today. Mr. Sen is indisposed.
Yes.
No objections, Lordship.
On pre-made by the Miss Leonard J has sought for accommodation on behalf of, on the ground that the Leonard conducting counsel, Mr. S. Sen, Leonard J is indisposed. As prayed for, this is matter up to 2 weeks.
Obliged, Your Lordship.
Brief, Lordship.